All right. Good morning to everyone. Hello and welcome to Unacademy. My name is Aditi Bhatt and I'll be conducting your session on daily legal current affairs, wherein we will be analyzing today's The Hindu newspaper. All right. So let's start with the session. So for regular updates related to classes, you can join my Telegram channel with the link that is given here, or you can also scan the barcode, right? And if you're planning to if you're planning to take any of the Unacademy subscriptions, then you can unlock free classes and discounts by using referral code ABCLAT. All right. Okay. So let's see today's highlights. These are some of the news items that we will be covering today. First is uh, just a second. All right. Okay. So the first is Apex Court transfers Erosulphin case to Kerala High Court. Okay, so we'll look into what this news item talks about. Then the next is probe can go on against Senthil Balaji, says Supreme Court bench. Third is apathy of family and high costs hinder maternal health care. Fourth, why spurious liquor kills. Five more deaths take spurious liquor toll to 22. Fifth is don't create a climate of fear. Supreme Court tells the enforcement directorate. Then sixth is SGPC offers free legal aid to man who killed woman over sacrilege. Seventh is Supreme Court rejects petition seeking review of EWS quota verdict. Eighth, collegium recommends Andhra Pradesh Chief Justice, Senior Advocate as Supreme Court judges. Then ninth, National Human Rights Commission flags rise in child abuse content on social media. 10th is Manoj Soni takes charge as chairman of a Union Public Service Commission. And 11th is arrested DRDO scientist sent to 14-day judicial custody. All right, so let's start with today's session. The first news item, Apex Court transfers endosulfan case to Kerala High Court, right? Herein, we'll look into this article. This news item can be viewed from constitutional law point of view. I want you all to understand the Supreme Court's power of transferring cases. Okay, so under Article 139, capital A of Constitution of India, the Supreme Court can transfer certain cases where cases involving the same or substantially same questions of law are pending before the Supreme Court or one or more high courts, right? So the Supreme Court basically has power to transfer cases. Supreme Court can transfer cases, right? And Supreme Court, if it is satisfied on its own motion and application made by Attorney General of India, then or a party to any such case, that such questions are substantial questions of general importance, then the Supreme Court may withdraw the case or cases pending before the High Courts or the High Courts or the other High Courts and dispose of all the cases itself, right? And then, of course, this is under the constitutional law. Then you have section 406 of CRPC, Code of Criminal Procedure. Now I'm reiterating it again. You do not need to remember the articles or the sections of different laws, right? Herein, under CRPC, also it states the power of Supreme Court to transfer cases and appeals. Cases and appeals. Whenever it is made to appear to the Supreme Court that an order under this section is expedient for the ends of justice, it may direct that any particular case or appeal be transferred from one high court to another high court or from criminal court subordinate to one high court to another criminal high court, right? If the Supreme Court feels that it is for dispensing justice, it is important for that case to be heard by the High Court, then of course it can transfer the case to the High Court. And right, Okay, so let's move ahead, move to the next article, next news item. Okay, so this news item states probe can go on against Senthil Balaji, says Supreme Court. Herein, you see there is a particular term that has been used here in this particular news item. The directions for de novo investigation. Okay. Uh, what is let us understand what is de novo investigation. De novo is a Latin term which basically means anew, right? Means anew, or something that's fresh, freshly ordered, or something like that. From the beginning, afresh. When a court hears a case de novo, it is deciding the issues without reference to any legal conclusion or assumption made by the previous court or to hear the case. What happens is generally whenever de novo investigation is like a re-investigation, when the court orders a re-investigation, right, or a fresh investigation, what happens is that sometimes the investigation that has been conducted previously by the authorities in matters, okay, whatever the results have been presented by the parties in the Supreme Court, so if the Supreme Court is not satisfied by the kind of investigation that has been conducted or by the process or whatever it may be, if the Supreme Court is not satisfied by generally such cases can be given to the Supreme Court as well as High Court. So both Supreme Court and High Court have the power to direct or to order de novo investigation, right? A re-investigation or a fresh investigation. Only if the court is not satisfied by the results of the investigation. As in, by if the investigation was not conducted properly or it was not conducted thoroughly in that case. Otherwise, it is considered that the courts must follow what ideally they are supposed to follow what the investigation that has been conducted or whatever the results are, right? If they are only if they are not satisfied, then they can call for de novo investigation. All right. The power to order re-investigation or transfer of investigation needs to be exercised judiciously and not at mere asking. It can be ordered only if the conscience of the court is shaken to the standard of investigation. Matlab, if the court feels that the investigation was not up to the standard, then it can order a de novo investigation. All right. Okay. Moving on. This article, this news item is they basically it talks about a report which states that apathy of family and high costs hinder maternal health care. Now this news item talks about prenatal health care and postnatal health care, that is pre-pregnancy health care and the postnatal health care, that is after the pregnancy. Generally what happens is that women, once the child is born, postnatal care, once the child is born and right, so women are not cared for enough by the family members, right? So that is what the news item talks about. But we look into what are the cases or what are the laws related to maternal health care or maternity in India. Okay, so we'll talk about the maternity benefit law, but in general we'll talk about what are the laws. So there are international conventions. So international, first of all, we'll talk about the international perspective. The international covenant on economic, social, and cultural rights. Was in 1966. All right. Then we also have International Labor Organization. talks about laws for pregnant women and pregnant working women. And the ILO also adopted a declaration. It basically adopted a declaration, or came up with the declaration on equality of opportunity for women workers. Right, this ILO adopted this declaration in 2004. Okay. Now, and in 2000, there was also this ILO Maternity Protection Convention. This was 2000 ILO Maternity Protection Convention. It stated that the protection of women workers during pregnancy was the job of the government as well as the society. India is a signatory to International Labour Organization, and therefore it recognized that its maternity leave laws need reform, right? So we had so first we'll talk about the article in the Constitution. So we have in our constitutional framework, we have Article 42 of the Constitution of India, which is a directive principle of state policy, which is under Part 4 of the Constitution. This article talks about provisions for just and humane, just a second, provisions for just and humane conditions of work and maternity relief. This was part of our original constitution as well. Now, so originally we had the Maternity Benefit Act of 1961. This was passed in 1961, and the statute, it includes conditional benefits for pregnancy, childbirth, complications related to those, in conformity with the international standards. The act covered a lot of areas with meticulous precision, and care was paid to many dimensions. It governed maternity benefits in India. Every organization with 10 or more employees is subject to the Act. According to the Act, maternity benefits are available to any woman who has worked for an organization for at least 80 days. So the condition is that the woman must have worked for 80 days. The maternity benefit, that is 80 working days. And Maternity Benefit Act 1961 aims to provide all the facilities to a working woman in dignified manner, so that she may overcome the state of motherhood honorably, peacefully, undeterred by the fear of being victimized or forced absence during the pre or postnatal period, as was observed by the Supreme Court in the case of. So basically, features of there are several features of Maternity Benefit Act of 1961. It provides duration of leave, job protection, remuneration during leave, financial benefits, right? And then, of course, I'll just write it here. In 2017, there were some amendments made in the there were some amendments made in the maternity law. Some reforms were introduced. So we had the maternity, we have the Maternity Benefits Amendment Act of 2017. This was introduced in 2017. Okay, now the period of so the duration was exceeded. So earlier the duration was exceeded. Earlier it was 8 week. Sorry, earlier it was the duration of leave for pregnancy was 8 weeks. It was extended to 26 weeks, right? The amendment offers 26 weeks of maternity leave, right? And the overall period of maternity leave has shown to increase by 117%. All right, then of course, it also provides for job protection. The original act's discharge and dismissal clause remains unchanged. So both the acts provide for job protection. Both the acts also ensure that the woman is being provided with financial benefits. No immediate financial benefits have been put into practice. Every business So see, the most important modification extends maternity leave from 12 to 20. Okay, so the earlier act basically provided maternity leave for 12 weeks and it was increased to 26 weeks. All right, and according to World Health Organization, the child should be nursed for 24 weeks after birth to lower the death risk. Additionally, it also World Health Organization ने ही ये जो 24 to 26 weeks वाला जो criteria है that has been set by WHO. All right. Additionally, it ought to lower the number of women quitting their jobs as a result of insufficient maternal leave. Maternity. Additionally, the longer period is given in accordance to the Maternity Benefits Conventions. Okay, so basically, this is all that you need to understand as far as maternity law is concerned, right? And there's also there are also laws in India related to abortion. So, right, that is Medical Termination of Pregnancy Act. So, since this news item does not cater to abortion, so we will not delve into it. But yes, we will in one of the sessions cover that act as well. Okay. All right. So the next news item talks about why spurious liquor kills, and the related item is five more deaths take spurious liquor toll to 22. So let's talk about what are the alcohol. What is the law related to alcohol in India? Laws related to alcohol consumption in India. Okay, so first we need to see the constitutional provision related to it. Yeah. So we have under the constitutional framework related to alcohol, we have Article 47 of the Constitution of India, which states the state shall regard the raising of the level of nutrition and standard of living of its people and the improvement of public health as among its primary duties, and in particular, the state shall endeavor to bring about prohibition of the consumption right, consumption of intoxicating drinks which are injurious to health. Okay, so this is the responsibility of the state to ensure that the people of the state are not consuming any such intoxicating drink which is injurious to health. Okay, now see, the alcohol, basically when we talk about the three lists, okay, so alcohol is part of the state list. All right, it is part of the state list. That is, I'll tell you, just a second. Yeah, alcohol is part of the state list. Okay, that is two, list two of the seventh schedule under the Constitution of India. Okay. And because it is part of the state list, so there is no central law, obviously, and therefore there are states that regulate laws related to alcohol consumption. So you must be knowing there are certain states which have banned the usage of and consumption of alcohol, right? For example, Bihar and Gujarat, right? But even then, in Bihar, last year or maybe this year, somewhere around that time, basically when you see a lot of alcohol related cases were coming up, right, last year also. So we'll look into what so states have their own laws related to alcohol. There are several states which have not banned alcohol, and the major reason is because alcohol is a very good source of revenue for states. Okay, so that's one reason why states do not ban alcohol, right? And so, what is the legal drinking age in India? So that also differs from age to age. The legal drinking age in India is also different from different states. Okay, and consumption of alcohol is prohibited in states like Bihar, Gujarat, Nagaland, and Mizoram. And Indian states permit alcohol consumption, but at a fixed legal drinking age. Right, in some states the legal drinking age can be different for different types of alcoholic beverage. Okay. uh, Liquor in India is generally sold at liquor stores, restaurants, hotels, bars, pubs, clubs, and discos, but not online. Some states like Kerala and Tamil Nadu prohibit private parties from owning liquor stores, making the state government the sole retailer of the alcohol. So you will always see there are no private stores owning liquor. There's always a state government has complete control of the trade, or the selling of alcohol. Okay, it regulates the sale of alcohol. Okay, so in every state, because alcohol is regulated by the state, so you will have the drunk driving laws, which are different in different states, right? Similarly, we have but the punishment for drunk driving laws are basically given the Motor Vehicles Act, which is a central law, and that punishment is thing is the same. Then, of course, you must have heard of dry days. Dry days are those specific days where the sale of alcohol is not permitted. For example, the Republic Day or the Gandhi Jayanti, right, or the Independence Day. Such days are observed, and even during elections, the sale of alcohol is not permitted. Then taxation of on alcohol, so because alcohols generate a lot of revenues for different states, so that's why there are several states in India that have not banned alcohol or prohibited the sale of alcohol, right? And So let's see what this particular news item basically talks about. The spurious liquor, that is, the World Health Organization has said something about the consumption of alcohol. What happens inside the body after methanol ingestion, and what are the industrial uh, applications of methanol? Right. So this article, it talks about ethanol and methanol. See, ethanol is not going into chemistry right now, but this is what is generally used in alcohol, and this gives the effect of hangover. So the consumption of alcohol is, sort of ethanol in alcohol is more or less like hangover. It is an intoxicating substance, right? But when sometimes there have been cases wherein the consumption of methanol has been seen, and methanol is metabolized by liver, and it causes the formation of, so methanol, right, just a second, methanol, and that is, it causes the formation of formic acid in the body, and it leads to, it is basically fatal in nature. Okay. So that's why a lot of methanol poisoning, it is, this news item talks about methanol poisoning, and that is why a lot of people die with due to the consumption of methanol, right? And that the news item also states that the use of, there are certain alcohols which have ethanol, and sometimes, the methanol is being used, and there is no such regulation, even in different states, which can talk about the use of methanol and ethanol. That's why, and which is why so many death cases are cropping up. Okay, so this news item is also related to the similar news item. Okay, now the next news item talks about, don't create a climate of fear, Supreme Court tells Enforcement Directorate. Now here you can see that Article 131 of the Constitution has been referred to. So Article 131 of the Constitution gives power, it gives Supreme Court, it talks about primary jurisdiction of Supreme Court over all interstate or center or central or so it has, first of all, it has primary, or what we can call as original jurisdiction. So Article 131 of the Constitution talks about the original jurisdiction of the Supreme Court. Okay. Now, for example, in cases between and states, center and state, okay, center or two or more states, right, or one state versus another state. So it can also be like that. Okay, so Article 131 gives Supreme Court gives the Supreme Court the power to deal with such cases directly rather than through lower courts or reviewing lower courts' decision. Under the provision, Supreme Court has the power to hear cases at first hand as against appellate jurisdiction. So this is original jurisdiction, that is, the parties who are disputed parties can come directly to the Supreme Court, right? They do not need to follow the appellate or the appeal process, so they can directly approach the Supreme Court. Okay, and according to Article 131 of the Indian Constitution, the laws of Parliament are considered valid unless the court decides otherwise. Interstate conflicts are common in India's quasi-federal constitutional system. The drafters of the Constitution foresaw such differences and resolved them by enacting Article 131, which gave the Supreme Court the sole initial authority. Supreme Court has been given under this article the sole initial authority. Just a second. Under Article 131, there is high probability of disagreement between states or between center and states, and the drafters of constitution believed that the decision making power should be clearly expressed in such cases. The Supreme Court has exclusive and original jurisdiction because it is the highest judicial body. Its exclusive jurisdiction, original jurisdiction, extends to cases related to Government of India and States of India. Okay, I hope you understood this particular issue. Okay, this is what I want you to understand from this particular news item, that is Article 131 of the Constitution. Now you can also refer to different types of jurisdiction of the Supreme Court, right? Different under different articles. What is the jurisdiction of Supreme Court under Article 32, under Article 136, right? Then under what is the epistolary jurisdiction? So you can also refer to those. Okay, we'll move on to the next news item now. So the next news item says SGPC offers free legal aid to man who killed woman over sacrilege. Now, what happened in this particular case is that the Shiromani Gurudwara Prabandhak Committee has offered legal aid. So what there was a woman, okay, who was drinking near the holy pond in the inside the premises of Gurudwara, and the person named Nirmaljeet, in this case the accused, he couldn't hold back his anger and shot the woman with his licensed revolver. Okay, it was an impulsive action as the act deeply hurt his religious sentiments. Okay, and you will see nowadays many such cases are coming up. Even now, recently, you will see a lot of people, def- uh, they forcefully are entering temples, right? They are entering the Jagannath Puri, or right now, of course, the Maharashtra state is also taking undertaking the special investigation team SIT probe on the Triambakeshwar temple. Forcibly, people have entered into that temple, even though it states that non-Hindus are not allowed. So there are a lot of things. You see, people don't understand that the religious places or the temples, mosques, or gurudwaras, the churches, they are not secular places, they are religious places. So they need to, they need to have some sanctity. So some sanctity needs to be restored to such places, and therefore you'll see such cases coming up nowadays a lot. Okay, so this, from your CLAT perspective, you need to understand the right to free legal aid, right? So, from the national as well as international perspective, the ultimate purpose of legal aid in India is to provide free and competent legal services to the weaker sections of the society, which ensures the opportunities for securing justice, right? So, that is free and competent. Free legal aid basically means you need first understand what is free legal aid. Free and competent legal services, okay, to the weaker sections of the society. Yeah, this ensures opportunity for securing justice, so that the person has an opportunity for securing justice. And this particular right to free legal aid is enshrined under Article 39A, 39 capital A of the Constitution of India, which is a directive principles of state policy, which means that it is the duty of the state's duty to provide free legal aid to whoever belongs to the weaker section of the society, or whoever requires free legal aid. The right, this thing should be such. Okay, so whoever is in requirement of free legal aid should be provided free legal aid or free and competent legal services by the state. So it is the responsibility of the state. And the first, there was this uh, very famous judgment, Hussain Ara Khatun versus state of West Bengal. sorry, state of Bihar, right? This is a 1979 judgment of Supreme Court, wherein Supreme Court basically enshrined, Supreme Court stated in this particular judgment about Article 39A, the importance of Article 39A, right? And hence the legal aid has been recognized internationally as well. So we'll look into what is the international legal framework pertaining to free legal aid. So we have the Universal Declaration of Human Rights 1948 UDHR. This talks about, it recognizes the right to free legal aid, says that everyone, so under Article 8 of UDHR, free legal aid, right to free legal aid has been recognized. It says that everyone has the right to approach the National Tribunal for effective remedy in case of violation of fundamental rights, right? And another, this is the first, and another second convention which recognizes the right to free legal aid is the International Covenant on Civil and Political Rights. This is 1996. Okay, this is basically ICCPR. 1996. Under this, Article 14 of ICCPR basically talks about everyone is entitled to fair public hearing by competent and independent tribunals, right? The accused should be informed about the offense and should be granted adequate time to prepare and the opportunity to be heard. Okay. And when we look at the Indian constitutional framework, the Constitution of India, so before Article 39A, let's see what are the fundamental rights related to it. So Article 14 also. Article 14 states that every person shall be treated equally before the law and ensures equal protection of law to everyone irrespective of sex, caste, race, place of birth, religion, etc. Right? And also Article 14 read with Article 22 clause 1, which states that whoever has been arrested cannot be denied to the right cannot be denied the right to consult and to be defended by a legal practitioner of his or her choice, and there is a basic principle of law that should be followed. So ye dono to hain, these are part of our, these are part 3 of our constitution. So ye kya ho gaye, fundamental rights. All right. And you will see that this concept has been also taken from administrative law. Principles of natural justice. Principles of natural justice. ठीक है, talks about ऑडी ऑल्टरम पार्टम. तो ऑडी ऑल्टरम पार्टम ये भी this is a Latin maxim. You should know these maxims because they can be asked. Audi alterum partem. Okay, so the meaning is that no party shall be left unheard. No party shall be left unheard. Okay, so it basically implies that everyone should be given a right to be heard, right? And similar things for Article 14 as well as Article 22 clause 1, right? The arrests of persons who have been arrested have the right to have certain fundamental rights, that is right to being consulted, right to being defended by the legal practitioner of their choice, and the right to be heard. Okay. Article 39 of A of the Constitution, as I already said, is provides that state shall secure the operation of legal system promotes state shall secure that the operation of legal system promotes justice on a basis of equal opportunity, and shall in particular provide free legal aid by suitable legislation or schemes, or in any other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disability. Okay, and then of course you have several laws, like under CPC also we have a law, that is Code of Civil Procedure, also states that the person people should get the right to be heard, right? Free legal services to indigent persons. The Code of Criminal Procedure also talks about under Section 303 that recognizes right of a person accused of an offense in criminal court to be defended by pleader of his choice. Then we have the Legal Services Authorities Act 1987. We also have the Supreme Court Legal Services Regulations. So all of these, we have laws, we have statutory framework, constitutional as well as international framework related to rights to legal aid. Okay, and even if it is a terrorist, even if it is a person who has conducted a heinous crime, even in those cases, just to ensure the principles of, just to comply with the principles of natural justice and rule of law, the person must be heard, the person must be given an opportunity to put on or put forth his case. So the terrorists have also been given opportunities in their right when the Mumbai attack happened and the Ajmal Kasab case, which went on for a really long time. So he was also represented by lawyers, competent lawyers, and he was also given right to be heard. Similarly, you will see in Nirbhaya rape case, okay, the Delhi rape case, you will see the people who had committed the offense of rape. It was a heinous crime, like it was committed in the most heinous fashion ever, and even those accused in the rape case were also given the chance to be heard. Okay, so the right to free legal aid is enshrined in our constitution because we need to comply with the rule of law and principles of natural justice. Okay, and the principle of odi alterum partem. Odi alterum partem, which means no party shall be left unheard. Okay, I hope this is clear. We'll move on to the next news item now. The next news item says Supreme Court rejects petition seeking review of EWS quota verdict. So EWS is economically weaker section society. So last year in 2002, a judgment was passed by the Supreme Court in the case of Janhit Abhiyan versus Union of India 2022. This case was passed by the Supreme Court, wherein Supreme Court upheld the validity, the constitutional validity of the 103rd Constitutional Amendment Act of 2019. Okay, so remember this 103rd Constitutional Amendment Act. This provided for quota for economically, or reservation for economically weaker sections. EWS, that is 10% reservation for EWS category people, so 10% quota. Okay, and the insertions were made in the constitution under articles 15 clause 6, which talks about special provisions, or the state making special provisions for, wherein the state is empowered to make special provisions for reservation of economically weaker sections and related to education, and here under article 16 clause 6 related to public employment. Okay, you need to understand the basic difference between article 15 and 16 is Primarily, first, because it talks about 5 criteria under which the discrimination cannot be made, and 16 talks about 7 areas wherein the government cannot discriminate, and then uh, 15 basically deals with education, both public as well as private education, and 16 deals with public employment, that is only government services, government jobs. Okay. So, for the economic reservation in jobs and admissions in educational institutes for economically weaker sections, the 103rd Constitutional Amendment Act was enacted to promote the welfare of the poor, not covered by the, so the people who are not covered by the 50% reservation policy, that is someone who is not an SC or an ST or belonging to socially and educationally backward class, SEBC. Okay. ठीक है. So if someone is not belonging to these categories and someone is economically unprivileged, ठीक है, economically underprivileged or not sound enough in that criteria, then those people will be uh, provided reservation under the EWS category, economically weaker section. It enables, so the Constitution Amendment Act, it enables both center and states to provide reservations to EWS category, center as well as state to provide reservation. ठीक है. All right. And so recently, the case was again there was a party who was the petition was again challenged in the Supreme Court regarding the validity of the EWS quota. So the Supreme Court has rejected that petition seeking the review of EWS quota verdict. So the petition has been dismissed by the or rejected by the Supreme Court. Okay, I hope this is clear. This is what you need to understand with respect to the economically weaker section reservation. All right. Okay. So we'll move ahead now. The next news item talks about collegium recommends Andhra Pradesh Chief Justice, Senior Advocate as Supreme Court judges. Here we will be talking about the appointment of judges and the collegium system. So what is the collegium system? Here they have stated collegium, right? So what is the collegium system? How are the judges appointed in the Supreme Court? Collegium system is a system of appointment and transfer of judges that has evolved through judgments of Supreme Court, and right, and it is not a statutory. It has not been evolved by Act of Parliament, but by provision of Constitution. So it is a system of appointment and transfer of judges, both Supreme Court as well as High Court. Okay. So there are several cases that we need to first look into. There's a first judge case. This was in 1981. Now, when we talk about the appointment of judges, right, there has been a controversy with respect to the word consultation. When you will look into articles of the Constitution, provisions in the Constitution, you will see that the judges of the Supreme Court are appointed by the President. The Chief Justice is appointed by the President after consultation with such judges of the Supreme Court and High Court as he deems necessary. So see, first you need to understand that the judges are basically appointed by the President. Now, to what extent can the President consult the Chief Justice, whether the consultation will be binding on the President or not, or will it not, or will it be on the President to appoint as per his wish. So that's what the word consultation has been under uh, controversy. So word consultation, and that is why we have a number of cases. right? So the first judge case in 1981, it provided that the primacy will be given to the CGI's recommendation to it. So if the CGI, the Chief Justice of India, is going to recommend the names to the president, then those names will be binding. So it will be binding. So the consultation will be given primacy. Then in the second judge's cases, this was in 1993. Supreme Court introduced the collegium system, holding that consultation really meant concurrence. So in this case, the Supreme Court stated that consultation means concurrence. Okay. It added that it was not the CGI's individual opinion, but an institutional opinion formed in consultation with the two senior most judges of the Supreme Court. So it stated that जो भी decision होगा CGI का, whatever reference would be made by the Chief Justice of India, will not be his own, but along with two other members of the Supreme Court, two other judges of the senior most judges of the Supreme Court will also be part of that collegium. Okay, and they will be recommending the name to the president. So it will be an institution on its own. Okay, right. And then came the third judge's case in 1998. Supreme Court on President's Reference, Article 143. So, Article 143 basically talks about, it gives power to the President to take any legal advice from Supreme Court. So, this is advisory. This talks about advisory jurisdiction of the Supreme Court. Advisory jurisdiction of the Supreme Court. And under this, in the 1998 judgment, the collegium a collegium of 3 members initially was expanded to 5 members. Expanded to 5 member this thing collegium, 5 member body comprising of Chief Justice of India and 4 other senior most judges. So comprising of CJI plus 4 senior most judges of the Supreme Court. Okay. The Supreme Court Collegium is headed by the Chief Justice of India and comprises 4 other senior most judges of the High Court, of the Supreme Court. And the judges of the higher judiciary are appointed only through the collegium system, and the government has a role only after the names have been decided by the collegium. So once the names have been decided by the collegium, then the names are basically recommended to the president. And then president, in consultation with the collegium, appoints the judge. So the government's role is limited to getting an inquiry conducted by the IB. So what happens is, when the name of the judge is recommended to the central government or the president, in that case, the president or the intelligence bureau conducts an inquiry or background check on that particular judge, on that particular person, whosoever's name has been referred to. For example, the Supreme, who can become the judge of the Supreme Court. So one who has been a judge of a Chief Justice of any High Court, right, can become Supreme Court judge, or a person, eminent jurist, can become a Supreme Court judge, or a person who has practiced for around 10 to 15 years in the Supreme Court, right, that person can also be directly from bar, they can also be referred to become the Supreme Court judges. So these 3 people can become Supreme Court judges. Okay, So the person whosoever's name has been recommended by the collegium, the intelligence bureau conducts a background check on that person, and once the green signal is given, once the person has been given clean check, or after that the president then appoints the person. All right. And this has been provided under Article 124, Clause 2 of the Constitution of India, that judges of the Supreme Court are appointed by the President after consultation with such a number of the judges of the Supreme Court as the President may deem necessary for the purpose, right? And when it comes to appointment of the High Court judges, then Article 217 of the Constitution deals with appointment of High Court judges. Okay. And yes, there was a reform initially in 2014. So the constitution was amended. So Constitution Amendment Act, and 99th Constitution Amendment Act, which was introduced in 2014, had basically brought in certain reforms. That is, it had introduced a body, National Judicial Appointments Commission. This body was set up under the 99th Constitutional Amendment of 2014, National Judicial Appointments Commission. Okay. But in 2015, there was a judgment by the Supreme Court under which the constitutional validity of the 99th Constitutional Amendment was basically it was held to be constitutionally invalid by the Supreme Court. Okay. Okay, so we do not have a national, we do not have NJAC. This was the NJAC. We are then, of course, after 2015 judgment, we were back to collegium system. So we do have the collegium system, but we do not have a National Judicial Appointments Committee or a commission. Okay, so this is what you need to understand with respect to this particular news item. Moving on. The next news item talks about two very important things. First is NHRC flags rise in child abuse content on social media. So we look into what NHRC is, National Human Rights Commission, right? And another thing is the child abuse content on social media, that is the online child sexual abuse, right? What are the laws related to online child sexual abuse? Okay. So first understand what is NHRC, National Human Rights Commission. NHRC is a right, it is a statutory body which has been formed under the Protection of Human Rights Act 1993. Okay, so PHRA 1993 may under this act, the NHRC or the National Human Rights Commission, National Human Rights Commission has been established, along with, of course, state human rights commissions and the district bodies. National Human Rights Commission has been established, and this is a statutory body and it is a quasi-judicial body. That means cases related to human rights violation can be directly approached or can be directly referred to National Human Rights Commission, right? Cases related to human rights violation, and then NHRC can give appropriate suggestions or recommendations on that particular issue. And if, of course, if the parties are not satisfied, then they can approach the court of law, right? um, and who is the chairperson of NHRC? Is always the ex or the former Chief Justice of India, former Chief Justice of India, or former Judge of Supreme Court. Okay, and when we talk about State Human Rights Commission, then the former Chief Justice of High Court or former Judge of High Court, that is the chairperson. Okay, in generally, when it comes to NHRC and SHRC, which is the State Human Rights Commission. Okay, and human rights, of course, we all know that it is covered under UDHR 1948, so Universal Declaration of Human Rights. इसी के अंडर फिर ये लॉ बना था, प्रोटेक्शन ऑफ ह्यूमन राइट्स एक्ट ऑफ 1993. ह्यूमन राइट्स डे कब ऑब्जर्व होता है? 10th December. 10th December is observed as Human Rights Day. Right? And all right, so this is what you need to know about NHRC. Okay. Now we're going on to child sexual abuse or child abuse content on social media. See, child CSAM or child sexual abuse material on social media. Let's see. So online, we're talking about online child sexual abuse cases. Online child sexual abuse cases. OC. So online child sexual abuse is any type of sexual harassment, exploitation, abuse that occurs through internet. ठीक है, online child abuse also known as cyber molestation. Cyber molestation, right? And online child sexual abuse can have serious psychological, emotional effects on victims, including trauma, depression, anxiety. The anonymity and reach of the internet can make it easier for perpetrators to carry out online sexual abuse and can also make it harder for victims to seek help or report the abuse. Of course, now we have dark internet, so a lot of things are happening, uh, right? And the children are also being forced to commit suicide, so there's abetment of suicide also happening through these online various platforms, various websites, and right, cyber crimes. Offenses include cyberbullying, grooming, sexual abuse. Perpetrators of online sexual abuse may use tactics such as coercion, manipulation, blackmail to control or exploit their victims. Right? Online sexual abuse is sending hateful or unwanted comments based on sex, sending unwanted requests for nude photos, videos, performing sexual acts on webcam without consent or in appropriate settings, sharing private images, videos without consent, or revenge porn, sharing porn in spaces where not everyone has consented to view, grooming children for sexual abuse online or offline, impact of online sexual abuse, right? Cyber stalking, again, along with cyber molestation, we also have cyber stalking. The cases have increased related to cyber stalking. So we look into what are the laws. So we have POXO. POXO is prevention of child prohibition of child sexual abuse, right? So okay, so section 11 subsection 4. Now you don't need to remember the section. Yeah, I'm saying, I'm just stating it. So it covers cyber stalking with sexual intent, as sexual harassment of child. And right, we also have section 14. It covers child pornography, provisions related to child pornography. Let's see what are the IPC provisions first. So IPC mein we have section 506 of IPC talks about punishment for criminal intimidation. ठीक है, punishment for criminal intimidation. 507 talks about, section 507 states criminal intimidation by anonymous communication. Right, someone who's concealing identity, and on online platforms it is very easy to conceal identity, and that's why many crimes are easily perpetrated. Then we also have the Information Technology Act of 2000. So this is the cyber law in India that we have. And section 67B of IT Act also defines child pornography. That is, it covers the law covers capturing images through video recording, photography, film, or any other means. Publishing the image in print or electronic form and making it available to the public is also considered a violation. And then you also have legal provisions under the Immoral Trafficking Prevention Act 1956. This So section 5 specifically talks about trafficking for the purpose of prostitution, forcing a child under 16 years into prostitution. Punishment is 7 years is minimum punishment, and maximum is life sentence. So forcing a child into prostitution. And section 11 and POXO May, section 11 and 12 of POXO also talk about sexual harassment of child cognizable. It is a cognizable offense, right? Sexual harassment of child. So we have different provisions in different laws, but we do not have one single law which talks about you know, online child sexual abuse, specifically targeting online child sexual abuse of any kind. So but we do have laws under IPC, we have POXO, we have the IT Act, right? We have the Immoral Trafficking Act. So we have different laws, and so when we read these laws together, then we can come up with specific targeted laws. Also, section 354A of IPC talks about sexual harassment of women, sexual harassment of a woman, including a female child, right, and provides for punishment also. So you see, these are some major provisions related to child sexual abuse and online child sexual abuse, right? Okay, so we'll move on to the next news item now. The news item states Manoj Soni takes charge as chairman of UPSC. UPSC stands for, so this you need to also remember this for your legal static GK point of view. Manoj Soni. Okay, this may be asked. UPSC is Union Public Service Commission. Okay. Article 312 of the Constitution of India deals with that, it talks about that Parliament is entitled to create one or more all India services, including all India judicial services, including all India judicial services. Now, all India judicial services, beach mein, it was recommended, but and but it was again, so we don't really have all India judicial services as such. So all India judicial services or all India services common to union and states. These public service commissions deal with recruitment to all the services under the UPSC. So we have recruitment of all the administrative officers, okay, Indian administrative services. You have IAS officers, IAPS officers, right? And you have Indian Foreign Services. You have the Indian Forest Services. So there are n number of Indian Railways, Revenue Service. ठीक है, so ये सारे के जो recruitment है, ये सब Union Public Service Commission recruits the people on all India level, and then you also have State Public Service Commission, which recruits people in the state for state services. These are for Union Public Service Commission for union services, and the State Public Service Commissions for the state services. Okay, this is the Central Recruiting Agency. Central Recruiting Agency. And this is an independent constitutional body. This is an independent constitutional body. Okay, provisions regarding the composition of UPSC, appointment, removal of its members, the powers and functions have been provided under Part 14. Part 14 of the Constitution. Under Articles 315 to 323. ठीक है, and 316 talks about appointment and term of members of UPSC. Article 316. talks about appointment of members of UPSC. The chairman of UPSC, or the chairman and other members of UPSC, are appointed by President of India. So chairman and other members of UPSC are appointed by President of India. Okay? So I hope this is clear. We'll move on to the next news item now. The next in this item is the last news item for today, which talks about arrested DRDO scientists sent to 14-day judicial custody. So we'll look into what is judicial custody. The word custody means apprehending someone for protective care. Apprehending someone for protective care. The word custody and arrest are not synonymous, so they are different. Custody is different and arrest is different. Right? Arrest directly curtails personal liberty of individuals. It strikes his freedom, but custody does not curtail a person's individual freedom. Okay, and there is a difference between police custody and judicial custody. So police custody, as you can see, the name as it suggests, so police custody is custody of the person and in the police. Okay, the police is the custodian of the person under police, whosoever is under police custody. Right, when following the receipt of an information complaint report by police about a crime, an officer of police arrests the suspect involved in the crime reported to prevent him from committing the offensive acts further. Such officer brings that suspect to police station and it's called police custody. This is arrest basically, right, by police. It is actually the custody of a suspect with the police in jail at the police station to detain the suspect. The objective is to detain the subject. To detain the suspect in the particular crime. During this detention, the police officer in charge of the case may interrogate the suspect, and this detention is not supposed to be longer than 24 hours. The officer in charge of the case is required to produce the suspect before the appropriate judge within 24 hours. These 24 hours exclude the time of necessary journey from the police station to the court. Okay, now what is judicial custody? Police custody means police has the physical custody of the accused, while judicial custody means accused is in the custody of concerned magistrate. So accused is in the custody of the concerned magistrate. In former, the accused is lodged in police station lockup, while in the latter, it is in jail. When police takes a person into custody, so uh, this particular concept is basically from your code of criminal procedure, right? And so this is just some basic concept that I wanted you to understand, right? The basic fundamental concepts, difference between police custody and judicial custody, right? Okay, so I hope this is clear. If you have any doubt or any questions related to any of the news items and concepts that we have covered today, you can please feel free to ask me in the comment section below. I would love to see some comments, and let's see what if there are any comments. Okay. All right, so okay, so we've completed today's session. Let's wrap up. You can join my Telegram channel for regular updates with respect to the classes, or you can even scan the code for joining the Telegram channel. All right. Okay, then. Thank you all for attending today's